We're getting ready to go live on YouTube Live for recording of the meeting. And just for everyone's knowledge, the mics that you all have are on all the time.
Okay.
If you want to talk to someone next to you, just hit the button like I'm doing now, so you can't hear me. And then we have to turn ours on, but yours, when you release the button, it goes live again in green and you'll be recording.
Okay.
So, oops. Oh, you're fine. Yep. That's the board, the planning commission and BZA now have all this same setup. So before we had a few months ago, we had, people that couldn't hear online. So.
Yeah, I've probably worked from home, which has been nice. I really got used to it. It's gonna be hard to change. I don't think we will. I think I was telling Carol, I think it's saying
Thank you.
From this how it works. And, I think I find a lot of people like
You want to be.
Also, for everyone's knowledge, when you place your cell phone closest to the mic, it can cause some interference. So you may want to put it in your pocket or separate it away from you there. Thank you. I found that out personally last time. So last meeting.
like that. Somebody's. Did you do that on purpose?
Think it might have been mine again. I set it on the floor.
It was changed.
Yeah, listening in on us. Yeah.
I didn't know he was talking.
I don't know. It's on the floor now.
Good for you.
Yeah.
Your clock says 6:59.
It's not still, is he still on his Payne business?
Yeah.
Business.
Stay busy.
Okay.
Good. It's good for you.
Well, good evening, everyone. I'd like to call the May 18th, 2021 Board of Zoning Appeals meeting to order. I'll introduce myself. I know there's some that I'm Douglas Miles, the Community Development Director. I also want to introduce our newest senior planner who will be presenting the Wayland case to you tonight is Jason Overstreet. Jason has 20 years experience in local and regional government, working as a GIS coordinator first at the Thomas Jefferson Planning District Commission in 1999 to 2000. Then he moved on to working as the GIS coordinator at Powhatan County from 2007 to 2017. And he's been with Fluvanna County here with us since November of 2019. He's a 1998 graduate of Mary Washington University with a Bachelor of Arts in Geography. And he and his family currently reside in Albemarle County. And he is enjoying working here at Fluvanna County. So at this point, I'd like to open up the nominations for election of BZA chairman.
Mr. Miles, I'd like to nominate Mr. Morris as the chairman of the BZA.
Okay.
Second.
Second, Mr. Van. Okay. All those in favor, please say aye.
Aye.
Okay, and I'll now pass it to Chairman Morris.
We have to vote for the vice chairman.
Yes, sir.
Mr. Chairman, I'd move to elect Dr. Von Kesserling as the vice chairman of the board.
Is there a second? All in favor?
Aye.
Next item, sorry.
Are we going to go to that right now?
We're going to go to the meeting calendar, yes. We're going to
How
adopt.
about the approving of the minutes?
This is the adoption of the 2021 meeting schedule for the remainder of 2021, which would be your June through December meeting dates.
I move we approve it.
I'll second.
Do we have a vote on that?
Aye.
Aye.
Everything's approved.
Your next item is the approval of your draft minutes from March 17th, 2020.
I move we approve the minutes from March 17th, 2020.
Second. Oh, I wasn't here. I wasn't here.
We need a different second.
I'll second.
Thank you, Carol.
I call for the vote.
Mr. Zimmerman.
Aye.
Okay, so that brings us to our application for variance.
Good evening. Okay, so we're here to hear the case variance BCA 2101, Edward and Mary Whalen. It's a variance request to section 22711B, setback lines to allow for the reduction of the rear yard setback from 30 feet to 25 feet in order to construct a rear addition on tax map 9, section 13, parcel 1. The subject property is zoned R3 residential planned community district. It's within Village Oaks residential subdivision. It's known as 8 Virginia Avenue. The property is located in the Palmyra election district and is in the Fluvanna community planning area. This is a general aerial from 2018 of the property location. If you can, it's the orange outline property there, right at the bottom of the screen. Would it help if we close that curtain that I opened over there? Thank you, Vince. Sorry about that.
And you all also have it on your TV screen in front of you there.
I think it has more to do with your overhead light.
Yeah, it's
I
the
think so
overhead.
as well.
Mr. Easton, could you hit the, Mr. Lovin, could you hit the, I think it's the switch closest to the fire thing there? Up the
That's
other
much
one.
better.
Yeah,
There you go.
turn that second one back on. There you go.
No,
Yeah, just turn them both off. Is that all right?
Yeah.
Okay.
Okay, next slide, please, Douglas. This is the current zoning. So they're in the R3 and it's A1 to the east and just to the south. The property is located at the end of Virginia Avenue there, as you can see. So the code section is 22711B, Fluvanna County zoning ordinance. And the relevant language is the bottom section there, the required Village Oak subdivision setbacks, front yard is 18 and the side yards are 7 and the rear is 30. So they're going for a rear reduction by 5 feet. That's what they're applying for.
Question, is that unique to that subdivision?
It is, as far as having just that particular, at the end of the lot with no other property except the one adjacent property owner to the north, as far as having open.
No, I guess my question is, it says the required Village Oaks setback lines. So are those,
There are 2 different setbacks for on the front and rear are both the same for single family attached or single family detached. The only difference is the side setbacks for single family detached are 7 as opposed to 8 for the attached dwellings.
And Mr. Loving.
Questions, is this the general zoning ordinance? No, this is a planned district.
okay,
Yeah, so the Village Oaks master plan, when they rezoned this, they established the setbacks at that time. And they are unique in all R3. So in Village Oaks or Sycamore Square or any other R3 plan community. So
that's my question.
Yes, sir.
Thank you.
So for the analysis, the proposed improvements is the applicants wish to construct a 25 by 12 addition onto the rear of their property, their existing home, and the impact on the adjacent property owners would be to slightly affect the view shed of the immediate adjacent property owner to the north, and perhaps the next two as well, slightly. No other additional impacts are seen for the property owners. This is a plat. Apologize, it's a little small. I tried to get that as large as I could, but it's oriented northeast to the top there. So you see the property is oriented. The front is facing to the west, Virginia Avenue. So there's a right of way directly adjacent to the front of their property, and to the south of their property is an open space part of Village Oaks. And then to the east of the property is the open space lot for the rural cluster subdivision. Okay. This is facing east from the right of way, looking at the property. I included this to show you the open space on the right there. And this is looking south towards their property from their property line. You can see their existing patio. So the variance would come out about 5 feet. Not quite 5 feet, about 3.5 feet from the end of that patio. The patio is actually in the setback, but it's not covered under the ordinance. This is looking same area looking towards the property line. You can't quite see it in this image, but it's staked at the top of the hill there on that swale.
So the trees are pretty much.
Right.
the property
Yes,
line.
sir. Yes, sir. Yes, ma'am.
Is that an empty lot next to the,
It's to the right in front of us or to the east there.
well, I can't really see
To the
the.
left.
the
Okay,
other-
that's in the right in the south where the pointer is. That's Lake Monticello
Right,
on the other side of Lake Monticello Road. So directly across the road is an open space strip that's part of Village Oaks subdivision. And then the lot directly behind them on the east is the open space lot for, what's the name of that?
River Oaks.
River Oaks, which is a rural
Mhm.
cluster.
Okay.
So they're basically surrounded by open space requirements other than their neighbor on the left.
Unless somebody else builds.
No, those are
No, those are
places where you cannot
non-buildables.
build an open space,
Oh,
ma'am. It's
okay.
open space in perpetuity.
So it's not going to affect anybody's view, right?
Ms. Walker, were you talking about the property? The grass looks kind of lumpy.
Lumpy, yeah,
Uh,
yeah.
That's another lot. isn't it?
Yeah.
That is in between the two lots of their neighbor just adjacent
This
to.
is looking now down.
Yes, it's the.
You're standing in the lumpy area
Mhm.
right here, looking down the backs of these houses next door to the Waylands.
Okay.
And as you can see from this picture, so there are 4 houses on Virginia Avenue here in this section of Virginia Avenue, and they're on the end, and the next three houses moving north all have either sunrooms or, well, they have closed screened-in porches, and then one right directly beside them has I believe is an enclosed porch. This is across the street looking south, so you can see the current configuration of the adjacent properties, that they already have these screened-in porches available. I wasn't planning on reading the considerations. If you'd like me to, I can, but
I think we know them.
Those are the findings.
yes. So we now have
Time for a public hearing.
5 minutes for a public hearing. Chairman?
Okay, we're ready for the public hearing now. Do you all want to speak on behalf?
You can, yes, sir.
Want to state your name?
My name is Edward Whalen. This is my wife, Mary Whalen.
Thank you.
We moved to Fluvanna County in 1975. I had a farm over in Kent Store for 40 years before moving over to Village Oaks, sort of retiring. When we moved in there and bought this house, we were the first one to buy that house on the end there of that street. We had asked the builder, O'Brien Homes, at the time if there would be any problem with adding on to the addition to our house. They told us at that time, they didn't see where there would be any problem whatsoever until we found out, getting paperwork and stuff together, that you had to go through the homeowners association for one, and then get a variance request to be able to add on 5 feet to the room as the 37-foot setback. If we would build, legally, we'd only have 7 foot to be able to build on, which is not a very wide room. So what we really requested was for 5 more feet, so we can make it 12 foot wide by the length that we wanted to go to. You have all the paperwork. The board, they approved our request. Southern Properties, they approved our request that we would be able to add on to the house. And our next step here was to see if we could get a variance of the 5 feet so we could build our room onto the back of the house. Is there any questions?
Anybody have any questions?
No, sir.
Thank you. Thank you.
Thank you.
Then we'll close the public hearing. then. Anybody on the board have a question?
Do we have any written comments submitted?
Which is second, Mr.
We
Chairman.
were just checking.
I just want to make sure there's no member of the public online.
Okay.
We've not had any comments submitted from any adjacent property owners by email or letter that we're aware of.
Okay.
Now, nothing is going to be built behind their house, is that correct?
That's correct. River Oaks open space is there perpetually.
All right.
And I was unclear on one thing. So this 30-foot setback, is that part of the covenants of the community?
Yes, Mr. Zimmer, when they rezoned Village Oaks to R3, they created a master plan. And with the master plan, they set and established their own setbacks. So the 30-foot rear yard setback is established through the master plan and the rezoning part of it.
The adoption of the master plan, though, sets the zoning setbacks.
Okay. So it's part of our zoning.
Yeah, it is both the private restriction and the public restriction.
And what's our normal, if this were not subject to the community there, their covenants and, their private restrictions, what would our normal, like in an ag district, butting up against that open space, what would our?
Well, this would be R3 if it were, it'd be similar to your R4 setbacks that you have in cluster subdivisions.
Right.
So it's very similar.
So
This,
30 feet. What would it be?
25.
it's already 25,
25.
It's 25 now.
correct?
If it were R4, it would be.
If it were R4.
25%.
Well, I see no objections to it, so I'm in favor of it.
Yeah.
Yeah, there's a couple of circumstances here that make it a little unique because of the open space. And I guess there are some question in my mind as whether or not we meet all the tests of the variance. But I'm inclined to support. I move to approve BZA 2101, a special request for variance for this particular property from 30 to 25 feet.
Is there a second?
A second.
Carol second.
All approved?
Aye.
Aye.
Any opposed? That takes care of it. That's it.
No, we have a new business item as well, sir.
Thank you very much.
Thank you.
Thank you. Enjoy your new room.
Good day.
Thank you.
Does Ryan put that on?
Easy changes.
Does Ryan put that on?
Oh, okay, there you go.
Thanks.
Chairman, I think Mr. Miles has deputed me to, staff you on this, this next item. These are proposed changes to the zoning ordinance, which are designed to reflect changes that have already been made by the General Assembly. So as a practical matter, they practically are part of our ordinance and legally will be hopefully tomorrow when the Board of Supervisors adopts them. And if you got a few minutes, I'll just tell you what they are. The brief point is there's not much that you really need to worry about. These are technical amendments that were designed to clarify some things with respect to appeals and membership on the board. The first one is in section 22-18-1B, the membership of the Board of Zoning Appeals. And as you know, members of this board are not permitted to hold other county offices with certain exceptions. And one exception is what Mr. Zimmer holds, and that is he is also a member of the Planning Commission. What they have done in addition is they've added an exception for an officer of election. And you can be an officer of election and also be a member of the Board of Zoning.
Fred,
Ma'am?
so I've been an election officer for years and years, so I guess that, I just assumed that was okay.
Well, I guess it is now.
They're gonna come.
Tomorrow night.
The sheriff's gonna want to talk to you.
Oh, I've talked to him many times.
Just don't tell Donald Trump. The next change is 22-18-2, powers of the Board of Zoning Appeals. And this one is one that I'm really glad to see. You all actually dealt with this issue before, and that is that you have a right in determining whether hardship exists if the hardship is occasioned by disability of the occupant of the property. And in effect, it just shows how far ahead of the curve you all were at the time you approved one of these. And the General Assembly's action allowed that specifically to be considered to be a hardship. And it also, later down in the same section, permits you to condition such a variance on the continued occupancy in the dwelling on the property of the person with a disability.
So an example, Fred, would be a ramp that might encroach on a setback for a person that needed access for a wheelchair.
That'd be one I know I've
But
dealings with.
conditional would be tied to that person living in that residence.
Right,
And
so
at some point.
if
it
that
could be
person moves
taken
out or
off.
dies or whatever, or ceases to have the disability,
Right.
then the variance would terminate.
But that's not automatic. We have to condition it that way.
Uh,
Because I can see a lot of.
I think
things-
that's right.
A lot of
We
things
condition
you would
it
allow
in the
can't
motion.
be reversed just because somebody moves out.
We had that one case
Yeah.
off Campbell Tires down from there.
Yeah, down below to the
So
right.
this is something we can or cannot, we can choose. or-
Yeah, the language of the statute is that it may expire. So
You build a structure.
Yeah, that's how I read it, was that we can condition it to expire, but
Yes.
we don't have to.
that's right. I would recommend that if you have one of these, you do put that condition on there.
I think it makes sense where it's reasonable.
Yes.
And let's see, the next one is very technical. It's in 22-18-4, and this is appeals from the board's decisions to court. And this is in subsection B1. And what it is basically cleaning up the procedure. And originally, for many years, the way you did this was if somebody wants to appeal from this board, you go to the circuit court and you file a petition for writ of certiorari, which is a common law writ. And then that writ has to be issued. And you don't have plaintiff and defendant, you have the relator who's the one asking for the writ. Then the writ issues to the Board of Zoning Appeals to send the record up to the court. The way it worked in past years was that it treated the board as a party to the litigation. So you were technically a defendant. Now, that never made any sense to me because the board is really in the position of a lower court. And you don't have a dog in the fight, so to speak. Well, the General Assembly has now corrected that. And what they've said is that the person appealing is still called the relator, but he's essentially the appellant. And there are two necessary parties in addition. One is the Board of Supervisors, and I'm too blind, can't read my thing. Wait a minute, I'm in the wrong section anyway. This is in actually 18.7. It's the zoning administrator and the Board of Supervisors are necessary parties. It also allows for additional parties. So, for example, if you had a neighbor that didn't like the thing, he could intervene, but he has to intervene as a party respondent. That you don't look like you're really excited by these changes, and I don't blame you because they're very technical, but they do make sense, and it cleans up the procedure. Now, let me go back to the one I missed here, and that was the in B1 of 18.4. That's 18.4 B1. This has to do with the notice that has to be given, and as you all know, there has been for some time a statute that says you can't appeal to this board unless there's a decision or a ruling, or I forget all the language, but it has to be a decision of the zoning administrator or somebody standing in the shoes of the zoning administrator, and it has to have certain language in it. And that procedure is preserved in this, and all this really does is to clarify how the notice is given. It has to be given by registered or certified mail, and then it specifies what addresses are permitted. Then the final ones are also in 18.7. Sorry to be skipping around on this. But what it does basically is it provides that in a normal court case, the court will assess costs of the court against the party that loses. So if you sue me and I win, you have to pay the court costs. You're the plaintiff, you paid them to begin with. But if you sue me and you win, I have to pay your court costs. This creates an exception to that there is no award of costs against the county unless it's a bad faith decision or something like that. And there's also similar procedure for going against the plaintiff if the plaintiff's appeal was frivolous. And that's about it. So I think I told you it wouldn't be very exciting. And I think you'll agree I was right.
Has that happened that the county has had to pay the court costs?
Yes. Assessment of costs is generally discretionary with the court. So the court, in most cases, the court has not been assessing the costs against the county. Costs do not include attorney's fees. So they're really, it's not big money one way or the other. Frankly, I don't remember what it would be for something like this, but it'd be less than $100 anyway. So it's not a big deal.
Thank you.
It's entirely possible, though, for us is that we act independent of the county in as much as their decisions are relative to the zoning ordinances, right?
You don't work for the county, you work for the court.
Correct. So we can go out on a limb and end up in a situation where we don't have the county attorney to represent us. Is that a fair statement?
You mean
In light of
you
any
think
of
I should
this?
have job security?
No. I'm not, Fred, I'm not questioning your job security. That's between you
Yeah,
and
that anyway.
Trish and
Immunity.
Moselle and the rest of you. No, I mean, we are independent in the sense that if we act outside the grounds of the zoning ordinance, that we may not necessarily have access to you as a county attorney. That happens
That's right.
quite often.
That's right. Because
Correct.
my responsibility is to the county, which is to say the Board of Supervisors and the subordinate officials of the county. Now, frequently, well, let me put it this way. One thing these changes does is that it takes away that conflict because you're not a party to the litigation. So let's say we take this case that came up tonight and you had denied that variance. And then the Whalens decided to appeal. If they appealed and won, even if let's say one of you had said, I think this is a perfectly good case for a variance, but I'm not going to do it because I don't like Mr. Whalen. That's obviously bad faith. But that would not, unless you had something like that, there wouldn't be an assessment of costs. Now, there could be an assessment of costs against the county if say Mr. Miles, acting on behalf of the Board of Supervisors, had come in and made a recommendation to you that was false because he didn't like Mr. Whalen, then the court could assess costs against the county. There's a procedure for doing that anyway. So again, this is not a big deal, but it does. I think these changes are salutary. It kind of cleans up the procedure.
Yeah, sounds to me like it did clean up a whole lot of
Yeah.
ambiguities.
Where does the final authority lie in
In the court.
Final authority for what?
yeah,
For what?
for anything,
Well, I mean,
enforcement, anything?
God Almighty.
God.
It's the final.
God, that's a phone.
Well, then God help us.
The circuit court and then it goes on to the Supreme.
Well, no, I mean, just in local, situations, we're an arm of the court.
You can really, I think you can visualize this. Put yourself in the position of a district court. And I sue Mr. Miles because he, kicked my dog. So I sue him in general district court. Just bring it to you as general district court judges. You find that my dog needed kicking, so you rule in Mr. Miles's favor. I don't like that, so I appeal to circuit court. Does that answer your question?
And it just stays in the courts.
Right.
So it just moves up as a normal court thing.
Yeah.
You're not like the Planning Commission, which is an administrative body. You're not like the Board of Supervisors, which is a legislative body. You are a quasi judicial body.
Always want to be a judge.
We just behave like it.
So you can refer to yourself as Judge Walker.
What's that?
You can refer to yourself as Judge Walker.
No, I don't want you to get any
Used to come up
concern
out
about
of the
this
judge.
line of questioning. Okay? So you tell the chair is getting concerned about this whole line of conversation. I don't want Harold to get uneasy and pass the gavel for any reason. Thank you, Fred.
Any new business, any old business?
The only thing I would like to request is just in seating order, when we convene again, I'd like to be closer to Harold. Thank you.
I don't have COVID.
No, it's just that I can't whisper at him from here.
Let me say one thing about that. You all may have heard that the CDC has come out with a recommendation that if you are fully vaccinated, they no longer recommend you have social distancing and masks. The governor came out with an executive order, which, to be perfectly honest, I find to be almost unintelligible. But it is really not clear. You know, some of it's clear, but for our purposes, it's really not clear. I think if you don't want to wear a mask and you're fully vaccinated, I think you're in good shape because you're covered by the CDC's recommendation, which is referenced in the executive order. I talked to Mr. Dahl today, and he's going to be issuing some guidance about use of county facilities and when you have to wear masks and things like that. And we're still trying to work through it and see, because this language is so ambiguous. But just for the record, ain't nobody in here with a mask on. I think that's perfectly appropriate. I'm assuming everybody has been, I know everybody, all the staff have been vaccinated, and I know I have, Mrs. Eager has, and I suspect everybody else has.
I have.
I think that was the one clear thing. Most of his executive order doesn't start till the 28th. The one thing I think that was clear was if you've been vaccinated, you don't have to wear a mask indoors. I think that was clear.
That is not clear, because there are certain things that say you have to do such and such, except with the CDC's recommendation to the contrary. And that starts getting to be too many double negatives.
I will point out for the record that Mr. Zimmer is a state employee, however, and he is concerned about this getting back to the governor's page.
I'm actually not. because
The governor would have to
The
come out-
order was very difficult to understand. And we had an entire meeting for the agency to figure out what does this say. And an hour later, we still didn't have it worked out. So
Well, we've had, my partner and I have both been chewing on this thing for at least 24 hours. And I think I can give you advice that what you're doing here is permitted by this order. I wouldn't say that somebody couldn't challenge that. One of my partner's concerns is not for me or the members of the board or Mrs. Eager, but for employees, because apparently CDC has come out with a statement, but the OSHA, the Occupational Safety and Health Administration, has not come out with a corresponding ruling. It looks like they're going to, and they're going to adopt the CDC's ruling. But as of this afternoon, they had not yet done that.
Fair enough. Do we have a pretty clean docket at this point?
You don't have anything else coming up before
Okay.
that we know of
All
for
right.
June or July.
Well, we've
that's-
matched their 2020 output at this point. So
I expect that's Mr. Loving's
one more
definition of a
meeting
clean
and
docket.
100% increase. over
I'm
last
catching on to this whole quasi judicial thing, Fred.
The Supreme Court says that.
Double our output.
Yeah, we will.
And
Chairman. Make a motion, we adjourn.
So moved. Second.
All in favor?
Aye. Now we can talk.
Good idea.
Hey, if someone came in